These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Welcome back after lunch. We're on the last day here. Hopefully it's not winding down to the point that the information is less useful. Oh, we've got a crazy computer operator here. What we are going to do right now is there is a person, an entity, that had a judicial foreclosure on real estate in Ohio. Now, most of the documents that you're going to see here, some of them are sanitized, some of them are going to have some original information that we may want to play with before we give it to you guys on download just to protect some privacy. Right here, right now, today, what we want to do is show you part of the process where in the private administrative process for settling a mortgage debt, this eventually, in Ohio being a judicial state, it came into the court. And I wanted to show you when we're doing some of this process to settle on the private side, then bring it to the public in the court, hopefully for some kind of a resolution. You can see about what these documents are going to do. Now, yesterday, Brandon showed you in a trustee state rather than a judicial state. Can you explain? Hang on just a second, then I'll let you interrupt. I want to bring you into the kind of the overall scope. See, Brandon was showing settle the account, settle the title, settle the possession. Now, with respect to what we're going to talk about here today, we're only on that area of settle the account and how it goes between the private and the public court. We're not looking at settle the title and settle the possession. Those are issues that are still going to come up. And we can go in the public arena of the judicial proceedings similar to what Brandon has done in the private when it becomes a trustee and you. But there's going to be some unique things that the court is going to respond to what we're doing here, which I thought many of you don't know how to read court judgments or court documents because you read and you think you know what the court's saying, but it's what the court is not saying that's more important. So we'll cover that. Yes, Mr. Gordon.
You keep talking about judicial and non-judicial. So, I hear you say you're asking people, this is a judicial state or a non-judicial? I'm lost. Can you help me?
Well, you either have a mortgage deed or you have a mortgage trust deed. If it's a mortgage deed in a judicial state, there is no trustee. And so consequently, if the bank feels that they're entitled to foreclosure, they've got to come into a general jurisdiction court and they have to file a civil action to foreclose on the property. If you're in a trust deed state, there has been a private trustee established under contract between the bank, the lender, and your straw man, the debtor, on the public side. And now that trustee, if he's notified by the bank of a condition here creating foreclosure, the trustee has certain powers in the contract to do that by a trustee sale without having to go through a court proceeding to get permission to do that.
So non-judicial means we're just not going to court, and judicial, in the layman's understanding, and judicial means we're going to be maybe going to a court where we have these filings and forms and things to deal with in front of the black-robed priest.
Correct. In a non-judicial state, the trustee is empowered to sell the property under the terms and conditions.
We never go to court in that sense.
In a judicial state, the judge is going to act like the trustee, but he only comes into that position when the bank files a civil case asking for foreclosure.
So if we're in a non-judicial state or a judicial state, that might determine how we go about getting our remedy, is all you're saying.
Correct.
Okay, got it. That was a little unclear.
What's happening in here is, in this particular instance, we're starting out with what I call document 5. Actually, this party has gone ahead and done an acceptance for value, return for value on a statement from the bank in which the bank said, hey man, you're in arrears, you owe X number of dollars, and we're foreclosing, so pay off the whole loan, $250,000, whatever it is, pay it all off and do it in the next 10 days, or we're going to file a suit for foreclosure.
So this is a judicial state deal.
This is a judicial state.
And so that also means that step 1 that we discussed yesterday, the private settlement of the account, has already occurred at this point. It may not have been in the same form that we discussed yesterday, where we were sending in our tender to Technical Support Division and then perfecting a process with the CFO of the bank. So we're assuming at this point that's document 1 through 4. Okay.
Right, and in reality, you can do it several ways. Brandon was sending it into technical support. Really, there's 3 parties that are involved. The beneficiary, obviously, is the bank. They want to get paid. The parties that are involved, if you're going to the asset side to get this thing done, unless you're just flush with a lot of Gitas out here in the public, where you're going to go down and write them a check out of a public account. If you're going to the private side, the other 2 parties involved are U.S. Treasury, Pennsylvania Avenue, Washington, D.C., and IRS. Now, IRS are the bookkeepers, but the funds are going to come out of your asset account and portal through U.S. Treasury. So they remove the funds from your asset account, deposit them in Treasury. Treasury then writes a check or a wire transfer to the beneficiary, the bank. So in your private administrative process, you could probably contact any one of those 3. Brandon said, contact IRS. They're the accountants. And empower them to withdraw the funds from your asset account through U.S. Treasury to wire to the bank. That was his process. In this particular case, the process was the reverse. You sent the A for V on the statement and the coupon which authorized the transfer of funds from the asset account, and you sent this to the CFO of the bank. Now, remember, all fiction has to be grounded on some reality to make it work. We've showed in the chart that you have in Brandon's words, the private trust, box 2, the surety, and you have the public trust, box 6B, the scarecrow or the straw man. The straw man is in the fiction. The surety, box 2, is in the Republic reality. On our diagram, we could have shown both box 6B and 2 as one box right on the line, like we showed you for the IRS, the DTC, and the FRB. The point I want to make, it doesn't make any difference what entity exists that you think exists in the fiction. It has to have one component of that fictitious entity touching reality to give it foundation. So if it's one of these things you call a public or private a corporation, private corporation like GM, it's really public, it's licensed by the public, it deals in the public. Any entity that is fictitious has to have one officer at least that touches in the private to give it reality. It's usually called the CFO or the CEO of that corporation, the Chief Financial Officer or the Chief Executive Officer. That one entity, or both of those, has capacity to deal in the Republic.
Jack, if we send something into a company and we don't know who the CFO is, or we don't know who that private officer is, can we send it in to the attention of the Chief Financial Officer?
Absolutely. But with today's Google and today's computer, you would be surprised if you just put in CFO of General Motors. You will probably go to a number of sites which are going to give you names and addresses. We put in CFO Internal Revenue Service and came up in a heartbeat with Allison Doon in Washington, D.C.
If I put in CFO for the Superior Court or for the Court of Common Pleas, Lorain County, is it common it'll give me the CFO?
Probably will. If not, you can contact the court and say, who do I write to if I'm writing to the CFO of the court? Usually the Chief Financial Officer on the court is who? The head clerk, not any clerk. Only one officer, because the head clerk takes the oath of office and is bonded. What are all the other people that work under her? Employees, not under oath, not under bond. So the CFO of the court is the entity that has the capacity to get directly to the DTC computer behind the wall in private.
And if I can't find him, I can just go ahead, because I'm going to tell you, I've had trouble when I go on trying to get a CFO of some of the clerks of the courts, and I call down there too, I can't get it. So I guess I'm okay with Chief Financial Officer. All right, just checking.
And you want to put the CFO, and then you want to put private, confidential. What did Brandon tell us yesterday when you're trying to contact some of these people? Didn't the judge say if you're putting private on there, what was the other word he wanted to put on the envelope? In camera. Something to maintain the fact that this is private. Or you might want to put on there that this is going to be in some capacity that it's going to be sealed against the public. Because if you're using your asset funds to set this off, if it goes to the public side and they see the asset account, what's their first reaction? This isn't a good account. You're going to the U.S. Treasury. You're stealing from the government. Because remember, in the public sector, they can't see above the line. So you got to get it to the CFO officer so that he is above the line so he can take care of it. See, even as the judge in the court has the capacity to look at the private documents, the CFO has the capacity to look at the private account, which is going to be debited, but nobody else can see that. Okay? Now, what we're doing here is this party was on a private administrative process. And he's asking for what? Time, because in the court they said that the plaintiff, the bank, was petitioning for summary judgment on their complaint.
Hold up 1 second. I need a little more clarification. We get behind in the payments. We've now started our administrative process. We A for V'd it. The bank has subsequently filed an action in court. Foreclosure action. Is this my first response to the foreclosure action?
In reality, I believe it was, because, see, they didn't even try to set it off and do anything administrative until a bank was into foreclosure. And there's a number of parties that were defendants in here. There was a husband, a wife, and a bunch of kids that had an interest recorded on the deed. And everybody was pretty much CS, chicken shopping, to the point that they didn't want, oh, I ain't going in there and doing something. I'll let the property go before they come and hang me. But we got the husband to be responsible enough that he was going to do a response to try to save the property. Okay?
So he puts in, so he already, let me get this, I got to get this in my mind. So I've got a foreclosure going, I start at A for V, and after I start my A for V, but it's not completed based on the inference here.
Correct.
I may not have finished, it looks like probably step 3. I may have got step 2 done.
Yep.
Step 3's not done.
Yep.
The bank files a foreclosure. This is my response.
Well, the foreclosure's been in there for a month, 2, and in the meantime, the administrative procedure, they went to the CFO of the bank, and they did the A for V and the set-off. And they told the CFO to set off, settle, and close the account. And then they also came back to the CFO then 30 days later and sent him what we call the B letter, which was your notice of fault and opportunity to correct. Now, the notice of fault was, gee, man, I sent you a letter. I haven't heard from you. See, what did you want the CFO to do? You wanted him to collect on the instrument, get the funds in. Where are they coming from? Behind the curtain. They're coming over here from the private side. Where are the funds? Debiting the husband's asset account. How do you know about that? Well, the asset account number was the red letter on the back of his Social Security card. Oh, okay. Can he do that? Well, let's turn it around. If you can't use that number, why'd they give it to you? So you're going to say, you know, I never filed a UCC1. You know, I never joined the DTC. I've just been sitting here like a good slave all my life. I woke up one day and I said, what the hell's that red number? And somebody said, oh, you could use that to set off your charges and accounts.
So again, the front of the Social Security card's public and the back is private.
Correct.
So that's the private number.
Correct.
Okay.
Now, this loan was issued on what? The Social Security number on the front of your card. So they're tracking this loan based on your account anyway. But you see, when it comes to the public number, only Congress can dictate how you can access that account through the public number. So there's billions, maybe, probably, who knows. But Congress said, if you want to get at them, then do a request. What is a requester?
Creditor?
A creditor. Do a request, but you got to fill out one of our forms. A request to apply Social Security funds from where? Out of your account. Haven't we been told in public the Social Security Trust is going broke?
They always say that, though.
That's on the public side. Pretty soon Congress is not going to allow any access to your property through the public. Can they deny access through the private? They don't control that. It's your property if you know about it. So you got to request Social Security funds if you're unemployed. Well, gee, if your straw man isn't unemployed, you don't qualify to get into that account through the public door. But for crying out loud, my public trust hasn't worked in 10 years, and I'm out of my public funds, and I'm going broke, and I'm losing everything. I'll go through your private door. Congress doesn't restrict you through the private door, if you know or understand. Okay, so what's happening here then is that this guy was about 1 week away from the end of the process. See, the first process was, I sent you the payment, why didn't you apply it? 30 days later, every count rolls over in 30 days. I should have seen they applied the funds. Oops, that guy didn't apply the funds. Gee, I wonder if there's a problem. I wonder if he got my letter. I got the green card, I got all this other stuff. And so you write him a second letter that says that you are in a state of default because you have neither ledgered the account with the payment, nor have you returned the instrument to me, nor have you explained to me why you couldn't collect on the instrument or why the instrument wasn't any good or if there was another problem. So I'm giving you a 10-day notice from here. Either ledger the account and cause this to go away, or return the instrument with some reason why it's no good, or bring in a counterclaim to my process telling me where there is an estoppel, either in terms of the amount not being enough, the substance contained in the instrument, oh, it's not real money, or the form of the instrument, oh, it's not proper, I can't collect. And if you fail to respond to me in 10 days, then you are stipulating, we're getting a contract agreement between the parties. And then you put on all the stipulations, and again you have it sent out by the notary for proof of service and the whole bit. If they don't come back for that in 10 days, then you go on to the certificate of failure to respond or certificate of protest or whatever you're going to do as part of the third-party witness that you've got an agreement and a contract, and the CFO is now responsible for the amount of this set-off.
Was he supposed to, on this, Jack, was he then supposed to, sound like he had second step done, he needs 5 more, he's asking for 5 more days.
Because he didn't have the COP or that third process back yet, and he needed to get that back through the notary public so that he had a record to put into the chambers of the court, so that he had a record to resist the bank's motion for summary judgment on their pleadings.
So the bank had filed the suit. And it was going along
Time went by.
Some time went by. He's doing his process, and then they put in some kind of request on a summary judgment. And so,
okay, the husband came back and he did a conditional acceptance on the complaint. He didn't answer the complaint. But if you look at the civil rules, it says that you must answer or otherwise respond.
What was his first response to the suit?
Conditional acceptance.
On what basis?
Proof of claim that the private set-off process hasn't made the foreclosure moot.
The private administrative process in play, or that it hadn't done it?
There's 2 processes. There's his private process going on between him and the CFO outside the court.
Right.
There is a public process going on because the bank filed a civil complaint for foreclosure.
And so he needed to get this in before.
He's doing his private record process to completion.
Right.
In the meantime, this public process is trying to push forward to get a judgment out of this court for foreclosure. And all the parties in the public were given an opportunity to respond to the complaint. But all the defendants defaulted and wouldn't respond to the complaint except the husband. He didn't answer. He didn't say, I agree with this fact, I disagree with that fact, I agree, and these are my affirmative defenses. The bank is scamming me, yada, yada, yada. It's unconstitutional. It's unlawful. They violated the terms of it. And so he just said, I conditionally accept this complaint on proof of claim that my administrative process, which I'm working on and I'm going to bring here, won't make the public process moot for foreclosure. So he's asking for time here. It was a simple asking for time. Now, I was helping this party, but many of the times I said, just go out and do the paperwork, and he did it in his words, and most of the time I'd look at it and go, well, maybe I'd do it a little bit different, but that's good enough. he needs to do it the way he can back it up. So he just said, now comes the defendant. He didn't even qualify the defendant. To respectfully ask for 5 working days to complete the set-off and settlement for the case. Defendant requests that this court is public, the court is private. Where is the private court? It's his administrative process outside, which is going to end up in chambers. Okay? The court for settlement. Defendant requests that this court grant its motion for time. Respectfully submitted. Now, I probably wouldn't have motioned, I'd have petitioned.
Well,
I like
hold
to
on.
do petitions and requests.
That's actually perfect because he came in as the defendant.
That's true.
It's a benefit privilege to motion. So you can't be an authorized representative of a secured party and motion the court. But
That's
the
correct.
defendant, a party named in the case, can motion the court all day
But
long.
see, the authorized representative could petition and request.
However, if I were going to sign this document, I would hand write the defendant's name, all uppercase letters.
Okay? So let's go on to the next document. I'm just showing you the progression of how this goes. Okay, now, this particular party got everything ready in his record. And so I suggested that he put it privately before the court judge in chambers. Okay? You're way down the line. We're on number 6.
I know. I was preparing. I didn't know it was going to come up so fast.
Okay, so what he needed to do is have some kind of a cover letter to usher in his private administrative process to the court. So this document, it's going to the judge in the case, and it's the record for administrative appellate hearing in the matter of the private set-off and settlement of a closure of mortgage instrument in this. That was the mortgage deed that was filed in the county recorder's office, and this case that's in there. And he says the undersigned defendant is the authorized representative of the defendant with authority to settle this matter. The undersigned offers no defense or excuse for the fact that the mortgage was not timely paid. Who's writing this letter, the private or public trust? Private, okay? Because it's a private letter. You notice there's no court caption on this sucker?
What do you mean by court caption?
Court caption is like State of Ohio, County of whatever, plaintiff so-and-so, defendant so-and-so, judge, case number, yada, yada.
Okay, just a caption in a court case.
That's a caption.
This stuff up here.
Yeah, you see, notice how anything on the left is debtors, anything on the right is creditors. Where's the court name? Middle. They're neutral. We take so many things for granted, but if you actually look at the construction of the way these court documents come down, they're so perfect in explaining what's going on when you understand what they're telling you. Okay, so the debtors are over here on the left. Notice both the plaintiff and the defendant are debtors, aren't they? Don't they both exist in the public? Anything in the public a creditor? No. In this case, the case number's on the right. Why is the case number on the right? It's the account which is collecting. Okay? So that's the caption. We go to number 2. We're in the private letter. So the undersigned offers no defense or excuse for the fact the mortgage was not timely paid. Forgive me. There's no argument. The undersigned asks that he be forgiven for the late payments by private discharge. The undersigned, in his private capacity, is an authorized representative of the all-capital letter at that address under that Social Security number account, is accepting full responsibility for the private set-off, settlement, and closure. Yeah.
Shouldn't the second sentence read, the undersigned offers no defense or excuse for the defendant?
That would be much better. Because it's
the
not the creditor's responsibility. The debt is the responsibility of the public trust. You're just coming to the rescue. Okay? So again, by having the paperwork up here, it offers a great discussion as to how to improve things. So the people that get this later on and just looking at it aren't going to have the discussion of what we're correcting. Okay? But there it is.
And now you also see the problem with just going to the websites and just downloading documents.
That's right.
Because it's going to go up on the website just like this.
There you go.
The names will change. But it'll go up just like this, and if you use it just like this, not to say there's anything wrong with this, but what is the undersigned just done? He identified himself as the defendant.
Yep.
Which is interesting because I found a similar error in Tim Turner's documents and pointed it out to him as well. Because he basically identified himself as, even though he was coming in as the executive. Tim Turner structures his documents slightly different. Rather than being an authorized representative, he comes in as the executive trustee of the public trust. And then he goes in, if you do not discharge these claims against me. Well, they don't have any claims against you. They got claims against the defendant.
Correct. You had a question?
Hold on. Let's get a microphone. I can't even hear.
Yeah, the authorized representative of
Michael John Smith. Now, Michael John Smith represents, in that particular case,
Well, that's implying the public trust, the all capital letter public trust in box 5 or 6B. Okay, because the one writing the letter is in box 2, but the authorized representative of box 2 is box 6A. So the letter is being signed by box 6A representing the surety in box 2 to help set off all of the problems against 6B, who is the public trust debtor.
And the judge is going to he's going to understand that?
Who is going to? The judge?
Yeah, that letter is addressed
This is going to the judge.
Right. So
He's going to understand in a heartbeat. Okay. I guarantee you, if you in here understand it, he understands it in a heartbeat because he's there collecting debts and he knows who creditors and debtors are.
Because I heard a judge say that an authorized representative of Michael John Smith, for instance, you can't. The only one that could represent Michael John Smith would be an attorney.
No. He's not representing. Forum? And he's not representing Michael John Smith.
He's representing the secured party.
Yeah. I know that it is.
Yeah, but it's written.
But it's written as
his private capacity and an authorized representative of basically the public trust.
The authorized representative is a title.
Right, but
it should be authorized representative. It should be of box 2, not box 6B.
Yeah, it should say the authorized representative of the
surety for Michael John Smith.
Right.
Okay, good point. Okay. Well, that's great. The students are correcting the teachers right now. That's awesome.
I'm going to tell you, that's when I started realizing that I was becoming quite competent at these processes, when I was listening to the Monday night downloads and watching the Winston videos and going,
there you go.
Winston made a mistake right there.
Yep. Okay. And that's fine because, like Brandon said before lunch, we do make mistakes. We're not perfect. And I'm helping this guy, and I'm trying to get him to do his own paperwork. And sometimes some of these things slip through. Yes?
In that same vein, shouldn't it be, I guess, the third sentence, where it says the undersigned asks that he be forgiven for the late payments? Should it be the undersigned asks that the defendant be forgiven?
That would be even better.
Okay.
Absolutely.
Okay, cool.
Because the defendant was the one that was supposed to show responsibility, but never does.
Yeah, you're speaking in third person. You're getting it. So
see, you guys are catching on that you don't want to identify yourself as the debtor.
Correct.
Especially when you're coming in on documents in your private capacity. Make the distinction. Because by making that distinction, what have you done? You've rebutted the presumption. And by rebutting the presumption that the executive of this document is the debtor, you've now established that the executor of this document is the creditor. So make sure you keep it distinct, separate.
Question.
So going back to the first process where he's actually doing the public side of the address as far as trying to get more time, should he have handled that a little different? Like Brandon said, he actually came in sort of as assigning himself as the debtor.
No. See, but he was coming in on the public side asking for a public benefit. That's why the first step, or document 5 there is perfect, because you don't want to go in your private capacity and motion the court.
You can't because you're not a party.
Right. You'd be confessing to being the debtor. You'd be confusing. You'd be showing you don't know who you are.
But that is a very good question. Why did we put the first document into the public? Yeah, because we want the public benefit, okay? But the public benefit, was that substantive or procedural? Procedural. Does procedural have to be colored or kind of hidden from the public? No. Procedural isn't going to harm your remedy. But if it's on the substantive side, if the substantive evidence goes public, that prejudices your remedy. They got to deny it. So you got to understand, are you dealing with a procedural issue or are you dealing with a substantive issue? If it's procedural, you can put the caption on it and put it in the public. If it's substantive, you better keep it in the private. Okay? Very good question, because now, we all hopefully learned something about pointing out why did the first one go in public and the second one go in private. This is what you got to deal with. Now, this is just portaling in his record. Second paragraph, the non-payment of the mortgage has been rectified by a private administrative process with the CFO of the plaintiff for the private set-off settlement closure of that should be AL, principal, penalties, interest totaling less than $160,000 on the note. Now, what was still remaining on the mortgage was about $140,000 plus some interest and expenses. The set-off settlement and closure funds are to be taken from the private account of name under the Federal Reserve Bank of Atlanta with an F number. Why is it Atlanta? F represents the Atlanta Federal Reserve Bank, and then there's 8 numbers after that, which is the bond account. So where's the funds coming to set this off? From your private account. Third paragraph, please find enclosed a copy of a letter from the undersigned dated November 23rd, sent certified mail to the CFO, to the private record of appeal, which is what's coming out of the notary public, and the supporting record, including an affidavit in support thereof, to set forth before the notary public who executed same. The notary public has a set of original documents in his possession. Now, original or a set of duplicates, actually originals have to go in this record to the judge in chambers. Now, this might be a lot more elaborate. For instance, instead of certified mail, some of those should have been registered. We've talked about that throughout the weekend. So this may not be quite as good or perfect as you might want to do, but we've discussed these things. We're here to discuss what it is and what it resulted in. We can always improve what's happened, okay?
Because this is working very effectively, even though it's full of errors, isn't it?
There you go.
Well, it's also taken into consideration that, we want to do our documents
we
perfect.
Want to go to what, number 7 first?
I just keep it in my head so we can keep up.
Okay.
We want our processes to be exact, or I don't know if exact's the right word.
As good as we can.
As good as we can. However, it is the judge's duty to use judicial discretion to derive the intent. So even if you make a couple of errors, the judge is to use his discretion to interpret the intent of the document.
Are you saying, in a sense, Brandon, that he's going to look at the entire document to determine the intent and meaning of the party?
Yes.
Very good.
Okay, now I've been calling this sucker here when I helped this guy record on appeal. Why appeal? We want to bring this to this court not on the theory that this is an answer to a complaint. If it's an answer to the complaint, then what did you just do to this court? You gave them the opportunity to judicially judge this. Oh, this is a complaint and this is the answer. And so isn't that an argument waiting for a trial? Okay? We aren't bringing the record in there for a trial. The trial already took place in private. Remember what Brandon was saying yesterday? See, if we, who's we? Private trust operating in the Republic, if we, private trust, as creditors, are involved, don't we want to hold the process in our jurisdictional venue, the Republic? Why would we, private trust, want to go to a foreign jurisdiction to hold a disposition on any argument with regard to our commercial affairs?
Has it not been said, Jack, that in common parlance, going to court is synonymous with going to trial?
Yep.
And so in reality, in an oversimplified statement, when we take our private process and we now go into a court with a judge, technically that is our first appellate court, is it not?
Well, look, the way it usually goes is since there is no money, there is no law. Since there is no law, there really are no courts. And so in place of that, under Title V United States Code, what is the highest form of process?
Administrative.
Administrative procedure. Isn't administrative procedure in the private between the parties? Absolutely. So your trial is between the parties in private. Oh, well then when some attorney files a court case, civil or criminal, what is that? That's your first appeal.
So like if the IRS is sending us letters, Jack, and
That's
we
your
ignore the
trial.
letters, we're already in trial, we ignore the letters, and by the time we get taken to the federal district court on an appeal, all they're going to look at is the record that was in the trial, and if we didn't answer those letters to the IRS, that's the only record in there and we're through?
Remember the rule in appellate court is the following. The appellate court is not there for the facts. The facts have already been established in the trial. And you can introduce no new facts at appeal. Now, all the patriots are going, I got this argument going with IRS, I'm not going to respond to them. Then their straw man gets summoned into court, and then they want to dump a bunch of evidence into the court. And what does the attorney for the United States do? Puts in a motion in limine to prevent the introduction of any defenses and evidence. Well, there you go again. It's just the crooked national government now allowing me my remedy. No, the so-called court case is on appeal, and you haven't raised any of these facts with the IRS in the administrative process, so you cannot introduce them in the trial, which you think is the trial, and it's actually the first appeal. Don't you see that your head has been in a box and you've assumed and presumed that the court trial was the trial when it's actually the first appeal? And if you went to the appellate court, that's your second and final appeal.
You never had a chance to start with, did you?
All of your evidence and record was excluded because it wasn't in the administrative procedure. So we had an administrative procedure. Do you think in a heartbeat the CFO ever answered us? No. So what happens when we go into court with our record? Does the CFO have a right to bring in an answer with argument of facts? No, we're on appeal.
No new facts.
Well, you'll see what does or does not happen here. Remember, whatever happens in the private is presumably real, and what happens in the public is a total fabrication and illusion. There is no truth at all in the public, so let's see where that goes. Okay, so this is the record on appeal, and it's got this caption that's going in, and it's got the private set-off settlement via the private bond, which is really the Social Security bond that this particular party has in there. Is that the only page we've got on that? Actually, behind this probably then was all the other records. So as we get into that, then we're going to... It may come up in a minute here. Affidavit in support of request for certificate of protest. Okay, the certificate of protest is what Brandon calls, you're not using protest, you're using
Certificate of non-response.
non-response, which comes out of a notary public,
Yes.
same as this, and it probably has affidavits and other records in support.
Absolutely.
Okay? Now, this particular party did not have a notary serve the documents on the other party. This party privately served and put proof of service of documents in. So whoever it is that did the service certainly has to have some kind of affidavit saying that these documents and I didn't get responses and yada, 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 so that this is part of the record going to the notary public, whereby the notary public could say, well, did they ever respond? You don't want to testify in person before the notary per se. So you got an affidavit saying, nope, I never got a response, but this went out and that's when he got it. Here's the cards and whatever, yada, yada, yada. Now, is that better to do your own service than a notary? No. Having a notary do the service, is that not a third party, totally unattached to the case? Yes. Isn't that better? Because you don't have to get up there and swear in and testify to anything, even process in your own case. Now, this guy may not be testifying to the substance of the case. He's only testifying to the procedures, which are important. But why have to testify at all? Because if you're under oath testifying, are you a creditor or a debtor? Debtor. But it's only on procedure. But why even raise the hint of any problems? So you can do it better. Did it have to be done better? Well, we'll see if anybody comes back and complains about it. Let's go on.
Next document.
Yeah, that's the tail end of the affidavit. Okay, we did a standard commercial certificate of protest.
Now, remember we told you about some of the codes that they want to change in regards to certificates of protest. A certificate of non-response, the way that it's structured, isn't like this. It doesn't have the receipt. However, you know what I would do to this document to change it up? I would leave everything the way that it is, and I would change the title to Certificate of Dishonor.
Good. Now remember, Brandon also said that this is wording out of the public. Mm-hmm. So it's a form that they'll understand. But would the substance of the process exclude a form created in private that substantially contained the same substance? Wouldn't exclude that coming from the private as long as the substance of the information in the form was the same, right? And then would that exclude the private form from a notary executing it if it wasn't styled as the public form? Probably not. Because their statutes would only deal with those forms styled as the public forms and not the private forms. And you got to understand, if you look at the intent behind the California law that's going to have the intent to try to limit who's going to execute certificate of protest, why did they feel it was absolutely necessary? Because they said that stupid patriot people, they didn't use exactly those words, were using these certificate of protests to lien public officials illegally and unlawfully. Are you using a COP to lien your brother? Or are you using it to set off, settle, and close your case? See, in one aspect, you're damaging your brother and charging him as debtors, and in the other case, you're using it to get a remedy where you are entitled to get a remedy. You're a creditor. Okay? This is signed by the notary. If you're doing this document or a similar document like Brandon is talking about, should your signature be on this document? It better not be, because this is equivalent to a judgment for $160,000 in favor of your private trust paying off the public trust. You can't give yourself a judgment. It's an oxymoron. And so if you're trying to write one of these instruments in which you're just reciting all the history of your administrative process, and you get down to the bottom, and therefore I'm entitled to $160,000 signed by me and then notarized, that's an affidavit of history. It's not a judgment.
And it's hearsay.
That's right, because it's an affidavit signed by you, and it is not authorized under the seal and signature of a public official in the due course of his business, which is the exception to the hearsay rule. Now, there's two instruments here. Certificate of protest, notice of protest are similar. Don't move yet. It's similar because what the notary is saying is under the auspices of the state of Ohio, county of such and such, presentment. Be it known that the person signing below, who's signing below? Notary. Person, he's a title of nobility. A duly empowered notary public at what? The request. Who is a requester? Ooh. A creditor came to this notary. How do we know he's a creditor? He brought a record. And the record supports that he should be a creditor.
I would have, in order to make the distinction of the separation between the public trust and the private trust, used probably upper lowercase on the creditor name there.
Okay. Did duly present at some date the attached.
Oh, and what's that address in care of? Whose address is that?
That would be the straw man. But
no,
it
no,
should
no, no.
be...
The notaries.
Oh, okay. Use the notary for
Right,
service.
because remember, the notary is the one who made presentment.
Right.
So it was at the request of the
Good.
creditor in care of the notary's address.
Good point. Now, this first date, this November 23rd, is the date that your initial A for V went out, because that was your tender of payment. So the attached banker's, see, your A for V, isn't that a banker's acceptance? They brought you something for payment. It was a statement. Didn't we talk about statements yesterday? The statement has two sides to the account. You owe us 160, but here's 160 credit if you want to use it. So when you did the acceptance on the statement, you say, oh yeah, please just apply the credit. And use it to offset the liability. And I'm authorizing it by endorsing the signature thereon, dating it, and putting the account through which this offer of credit goes. Where does the credit come from? Out of your asset account. Then there's a coupon down below, or if there isn't, you've got to generate a coupon. And that's going to be the monetary instrument by which they're going to pass it from the banker who's going to debit the funds, DTC, to the banker that's going to credit the funds. That's what that's used for. Okay, so that went out, which was the banker's acceptance, and this acceptance went out the same date it was put on to the CFO, signed by the signature of the authorized representative for the surety, requesting what? Post-payment of the banker's acceptance to set off, settle, and close the funds in that case, which happens to be the amount of the foreclosure. The time having elapsed for acceptance thereof and providing clarification of settlement and closure, which was refused. The CFO never applied it to the account. He never answered and never raised a defense. See, that's what happens to the patriots when IRS is in an administrative procedure and they never write back. So in reality, you know what the IRS ought to be doing is getting a certificate of protest against these people. But they don't want to do that because a certificate of protest has to do what? It has to move between two foreign countries. You cannot do a certificate of protest domestically. What's that mean? That the certificate of protest does not apply if your public trust, the straw man, tried to pay off the debt to the bank. They're both in the same jurisdictional country or venue. They're both in the democracy. So the reason why most notary publics don't understand certificate of protests or these kind of instruments is because it has to have the assumption of an internation transaction. And they're going to go, well, wait a minute, don't you live right around the corner and the bank's down the street? This is not international. Now, if the notary said that and wasn't going to process it, what would you have to do to rebut the presumption? Bring in a UCC filing, two separate entities, two jurisdictions. Are you testifying? No, you're bringing a government document in to show two entities. You understand why some of these documents might be valuable? And you understand really why the certificate of protest is only applicable because you're trying to pay off a public liability with a private asset. They go across international lines. See, if you understand what's going on and they try to trick you by saying we can't do this, you ask them the question, well, why can't you execute certificate? Well, I don't know how to do that. Are you telling me that as a notary public you weren't trained to do your job? Well, I've never done one before. Well, are you telling me that maybe you've never dealt internationally between two entities across international lines and that you've got consideration that maybe the party that is the requester, which is another good reason why it ought to be upper and lower case, and the bank, who is the beneficiary, are not international and a certificate of protest is appropriate? You see, if you understand what's going on in the background, you don't want to explain to them their job, because if you say, you're going to do this because you have to do this, that's a dishonor, isn't it? And who does the notary public work for? Secretary of State of Ohio. Who the hell are you as a foreigner demanding of them what they're going to do? You got to be a requester and act in honor as one of these creditors. If you treat them with disrespect, what just happened? You acted like a debtor. They say, pack up and leave, man. I'm not doing it. You dishonored them. You're acting now like a debtor, so obviously you're not the requester. You see how everything fits together? Okay, so this is being served on, the certificate of protest goes to who? The creditor. Who's the creditor? The requester.
No. The undersigned notary public certifies that on February 3rd, 2010, that should be notice of protest was sent to the party noted below by depositing in the depository of the United States Postal Service within the state indicated herein a sealed envelope containing said notice directed to the respective persons.
Certificate goes to the creditor,
Right,
notice goes to the debtor.
No, notice goes to Paul Ince, the CFO.
That's correct. That's on the next
this
one,
should
notice
actually,
of protest.
Right, but this is to have a protest, you have to have in there a clause that says notice of the protest was sent to that party you're protesting, which is the CFO. So
But
the
that's
CFO's
on the next
name,
page which he's executing.
Right, but the CFO's name and address should be here because what you're saying in this paragraph is notice was served on the CFO of their dishonor.
Go to the next doc. This is the notice of protest, and notices of protest were sent to the parties below which is the CFO.
Right, but your certificate is really referring to this notice as the notice that got sent out. Because it's the same on the notice, the certificates of non-response.
Okay.
Except typically, because of the structure of my process, mine would say notice of default in dishonor or something like that.
What we have done is we've sent notice to the CFO.
Right. And
the
this is the notice.
certificate original went to the creditor.
Right, but you don't say that it's not served on the creditor.
I consent to that. That's good point. Okay, the important thing for you to understand is that the original executed certificate of protest or its equivalent does not go to the debtor. That's an original. That's like money in the bank. That's like a receipt for the goods. When you go to the store and you buy something, what are you purchasing? You're purchasing the receipt. The goods are merely the inducement to purchase the receipt, because the receipt is the title and you're buying a title. So you're walking out of the store because you bought a title. That's all they're selling in their world. The real goods were created in the real world, and that was just the prize that went along with the purchase of the title. So the Federal Reserve notes, which is nothing, didn't buy any substance. It bought a piece of paper saying you were entitled to take the substance out of the store. So what you're getting here really with the certificate of protest is the good title to the merchandise, i.e., didn't you just get the receipt? And by getting this receipt here, what you have done now is you can waive that receipt as you got the title to the property, or should have. Actually, it's the receipt on the commercial side that you've zeroed the account, and once the account zeros, what is the consideration the other party is supposed to return to you? The title, which is the receipt. So your certificate of protest is as good as money. And that's what you're going to use it for, because, see, when you go into court, what does the judge want to know on the foreclosure? Did you pay them? Isn't that all he wants to know? The bottom line is the judge's going to say, did you pay the bank? Yes, Your Honor. Well, where's your evidence? Here it is, Your Honor, certificate of protest. Let me see if that's proper in form with supporting documents. Yep, okay. Mr. Attorney for the bank, what do you have to say? Well, Your Honor, that's a bunch of gibberish. Okay, is that all you have to say? You see where we're going with this? But you see, this certificate of protest was based on money or funds coming from where? Private side. So can you file a certificate of protest as your original evidence of receipt on the public side of the court through the clerk? No, because they cannot, even though it's a certificate of protest, they cannot have the information or the evidence of that private account in their record. They'll deny it in a heartbeat. So if you put that evidence in the public side, of necessity, they will deny that there was any payment on the bank. And you just went through your whole process for nothing. Yes?
Is it okay to use the word pay when talking to the banks, or should we use the word honor?
There's no money to pay. You sent consideration.
You could say tender for set-off.
Yep.
All right, honored my obligations, that's all right too? Or?
In what context? I was writing.
If you're talking to the judge in the bank, can you say, gee, I paid my bill?
I would say that a tender for set-off was issued to discharge, settle, set off any and all obligations, liabilities, and duties
and a record
associated with the account.
substantiating this is now before the court.
Because if we say pay, we could, in a sense...
Yeah, the judge may come back on that and bite and go, what did you pay with, sir? And now, is the issue what you paid with, or is the issue really that you've got a record that has not been rebutted for discharge of the claim? See, if you raise an issue and you throw out a word like that, You just opened up a line of inquiry, and you don't want to open that line up. Because if the judge says, what did you pay with? Are you going to testify? You're going to explain? You see what you just did? You opened up a can of worms, bringing you back to debtor. So don't go there. Remember, you got to be very careful what you bring into the court, because you might not like where it goes after you get it in there. And you can undo your process in a heartbeat and move from creditor to debtor. Well, let me explain for the next hour, Your Honor, exactly what I mean by pay, because I am an expert on the field of money. Beep, wrong. There you go. Okay, so let's move on, because the real interesting stuff is coming up. Oh, this is good. Okay, remember, here's what happens. Ordinarily, you go to trial, and if you don't like the outcome of trial, you go to appeal, right? And there's different rules. In trial, you argue the facts. On appeal, you argue the law. There's other interesting things. A trial court can only see the facts that appear in that jurisdiction. The trial court can only attach a recommendation of law based on the facts it sees that comes from that jurisdiction. An appellate court then can attach an issue of law which is even foreign if the record of facts show that foreign law is appropriate. Now, in the public system, they've got some interesting concepts going on. The lower court can only see domestic law, democracy. And they can't see your funds coming out of the republic as an issue of law to discharge, set off, settle, and close that account. But if you only tried in the trial court the issue to a judge, the judge could never see your private record and take it into account on his decision. Which means you'd always have to go to the appellate court for review to get your record straightened out, right? But when it goes to the appeals court, don't they publish the outcome of all the appellate decisions? And they don't want to have to publish something that might embarrass the public by having to recognize your private process. So in order to get around that, they create a little artifice. They put 2 court sessions in the lower court. The first court session is to a magistrate who is not a judge. And the magistrate is appointed in the capacity of the trial judge, the fact finder. And then he will find the facts, and then he will write up his decision. And they will send the magistrate's decision out to the parties. And as you will see, they will allow the parties to object to the magistrate's decision if they don't like it. And then the magistrate's decision, along with the objections, will then go to the judge in the same court. And they're going to warn you that if you don't put down your objections to the magistrate's decision with specificity, you are not allowed to appeal to the appellate court any of those issues. So in reality, what the hell did they just say? The magistrate is the trial, the judge is the appellate court, and you're still in the lower court that hasn't got to publish a decision. So you better know what you're doing, and you better take advantage of your procedure, because if you miss the procedure and don't follow it, you haven't got a remedy. You blew it. Now, let's find out what the magistrate, who is the public trial officer, is going to find in terms of the trial, because by this stage of the game, the bank's got their complaint there. Hey, man, we loaned this guy money. He was a deadbeat. He didn't pay us. We are entitled with our mortgage lien to foreclose. Okay, let's start out in the beginning of what we're reading. It says, magistrate decision written by the court. This cause was submitted to the magistrate and heard upon the complaint, the motion for default judgment of the plaintiff, the motion of summary judgment of the plaintiff, and the affidavits and exhibits in support thereof and answer of defendant so-and-so and the evidence. So we've got the complaint of the bank, the motion of the bank for default judgment, the motion of the bank for summary judgment, and the affidavits and exhibits of the one dude who came in, i.e. the defendant, and responded. Paragraph 2. The magistrate finds that all necessary parties have been served with summons according to law and are properly before the court, and that the defendants A, B, C, D, E, F, G, and everybody else, and their heirs and everybody, spouses and assigns and unknown guardians and incompetent heirs, are in default of answer or otherwise response to the complaint. Notice the one party not included in default is the one defendant that responded. Okay, next page. And are thereby, we go too far, and are thereby confessed the allegations of the complaint to be true. What happens when you fail to respond? Confess judgment. And said defendants are what? Forever barred from asserting any rights, titles, and interest in and to the hereinafter described premises, i.e. the property. Third paragraph. The magistrate finds that reasonable minds, that means insane people in the public, can come to but one conclusion. Remember, the public's always backwards. Which is adverse to the defendant, nice guy who responded, and that there are no genuine issues of material fact, and that the plaintiff is entitled to judgment in its favor as a matter of law. What did the magistrate just say? The defendant that responded, I can't see anything he's got here, he loses. What didn't it say? It didn't say that the interest of the defendant that responded is hereinafter barred from asserting any rights, titles, or interest in and to the described property. What just happened to our hero? What it doesn't say, it didn't say he must have rights, titles, and interests. Gee, I wonder what those might be. Are you beginning to understand how to read these things? It's not so much what they're saying, it's what they're not saying. If they didn't say it, they didn't say it. Next paragraph. The magistrate finds that there is due the treasurer of the county taxes. Okay, big deal. The magistrate finds evidence adduced that the plaintiff is owed 130. Our hero set off 160, right? Plus interest. The magistrate further finds that in order, watch this, to secure the payment of the promissory note aforesaid, that the defendant, his wife, executed and delivered to the plaintiff or the original mortgagee designated therein a certain mortgage deed. Okay, so there's a lien. And then they describe the property. Let's go below the description of the property. We don't need to go through all that. Hold on. The magistrate finds that said mortgage was duly filed in the record. Okay. It is a valid first lien, subject only to the lien of the treasurer for taxes. Why is the treasurer's lien more priority? Huh? Who's got the only legal title to the land? The county. So the county's treasurer has priority. Look, the bank had a mortgage deed. Did it file the deed in the county recorder's office?
Yes.
When it filed the deed, who'd they transfer legal title to for the mortgage? County. You had a warranty deed, but you filed the warranty deed. Who's got the legal title to the land? County. So the county's got the defendant's legal interest. The county's got the bank plaintiff's legal interest. And the county treasurer has the priority lien. Who's the only one in this court on foreclosure with a claim? The county. Everybody else's debtor is going to share some interest. And who does the judge work for? The county. Who does the sheriff work for? The county. So in reality, the county's just trying to decide which one of its slaves is going to get something and who the new tenant's going to be. Are they doing anything illegal? Unlawful. Outside their authority, which you people gave them. It's just collecting a debt, that's all, according to your wishes. Okay, so that's a valid first lien on the property, and that conditions in the mortgage deed have been broken by reason of non-payment because he can't see the private record. Remember last night, the prosecutor couldn't see the record, only the judge could see the record. But we're not up to the judge yet, we're still at the magistrate. You see how this game goes? All right. The magistrate further finds that plaintiff may have advanced some money, which it's entitled to. The magistrate further finds that there is no just reason for delay in entering judgment for plaintiff. Okay, sir, let's move on to the rest of the letter. It gets better. No, you got to go back up a ways because there's no reason for just delay. Did I miss a paragraph up earlier? That the said condition of the mortgage had been broken non-payment, finds that the plaintiff has advanced by which the amount will be ascertained at the time and added to the first mortgage lien. Someplace in here there is a paragraph that says that there is a party which is liable yet on this debt. Guess who the party is that is liable on this debt? Who would you think of everybody we've read so far? Who? The defendant that appeared. He's the only one that the court's holding liable on this now.
But that's only because the magistrate cannot see.
Yeah, but why aren't all the defendants liable? They're barred, but I mean, if there's a deficiency here on, if they don't get enough money out of the sale of this property, somebody's got to be liable. But somewhere in here, we don't want to take the time right now, but it specifically says that the defendant that responded is hereby liable. And I go, perfect. Why is he liable? Because he gave, remember yesterday when we said you give a second note? What does it have to do with the original contract? Cancel the original contract. Who is on the original contract? All the defendants. But they have to cancel the original contract. So if there's any problem from here on out, who's liable? Only the guy on the second instrument. So what did our hero do? He went in, sacrificed himself, like Brandon did in the corporate case. And the only one responsible now is the guy that went in with the second note and set it off. See, right now the magistrate is presuming he can see the second note. He can see it. He can't see that it comes from the asset account, but he can see the second note, and in his mind, what did it do? Under the Uniform Commercial Code, it's subrogated, but in reality, what it did, it had to discharge the underlying first contract. So the people in the first contract that didn't respond are gone, but they don't have any liability either because they were part of the first contract. You understand what I'm saying? I'm telling you, these people know exactly what we told you. Now, when you get this in the download, read through it. It's just a brief little, but you'll find out that's what it says. And so the one guy that appeared by giving the second note got everybody else off this case. And it's evidence that what I've been telling you and what's in that article by Judas Shapiro is absolutely true. Okay, let's go to the next document then. Isn't it amazing what you learn in what they tell you? Okay, now, here's what came out of the court. Notice, pursuant to our Civil Rule 58B, notice is hereby given that the judgment was rendered in the above captioned case and was entered on the journal of the court on 2/26/10. The ink wasn't dry on the magistrate's decision, and they entered an official judgment into the record of the court. Now, if you go back to Civil Rule 58B, and I think I've got a lot of those on there. If not, you can Google the Civil Rules of Procedure in Ohio and pick these up. It'll tell you that the court is entitled to ledger the decision by the magistrate as the judgment of the court any time after the magistrate enters that. But then it gives some process that if somebody's going to make an objection, you can come back then and they will basically suspend this during the time that the judge is listening to the objection. On the tail end of that previous decision, it said something about, at least I think it was there, not here. Let's go down to the bottom of this notice. It was probably on the last. No. Well, let's go to the end of the foreclosure judgment 10. Would that be it? Down to the bottom, underneath the signature. There you go. Notice, a party shall not assign his heir on appeal the court's adoption of any finding of fact or conclusion of law unless the party timely and specifically objects to that finding or conclusion as required by Ohio Civil Rule 53D3. See, they're telling you, if you don't like what the magistrate said, you got to come back and place a specific objection before this goes to the judge. Otherwise, you can't take it up on air on appeal to the appellate court. They won't hear it. Okay? Now we can go on. Yeah. You'll get your mic.
How do you find a matching civil rule in our state?
Well, this is rules of civil procedure in courts. So you'll go, let's say you're Georgia, you'll go to Georgia's civil rules of procedure, and they will have them there for the courts. Now, California is really inclusive. They got books and books and books. They spell it out so that the dumb people that live in California can understand exactly sorry about that. I mean, they're beautiful, because if you have any idea that you don't know what's going on, go to California and they just spell them out, sentence after sentence.
Okay, but that's the Rule 58 for Ohio.
Right. There are books and stuff that will probably translate 58 in Ohio as 61 someplace else or something.
Okay.
I'm not familiar, but it is.
Okay.
Ohio's rules of civil procedure tend to track the same number of rule in the federal, at least it did. And so if you need to translate that way, it's between Fed and Ohio. Okay, let's go to the next one then. It's just going to get better. What is the magistrate's decision really? What is that? Think Gordon. What would Gordon tell you that was? An offer. Would you be willing to accept this? Or, in the immortal words, who the hell is the court to tell me how to do my business? What authority do they have over a sovereign? Okay? So, along came This is, quote, defendant's conditional acceptance of magistrate's decision request for ruling on extended evidence and ruling on law. What are we going to object to the magistrate's report? What would happen if we objected to it? We're arguing. Are we a debtor or a creditor? Debtor. And if we acted like a debtor, what power do we give the judge? The power to rule out of his jurisdictional venue on it. And who is he going to see us as? A debtor, so he's going to use public policy, right? So I don't recommend anybody actually objecting to that thing by argument. Now, this party came to me and he had the decision of the magistrate, and he's got his tail between his leg, and he goes, oh man, I don't know what we did. We must have screwed up. We lost. I said, lost? You can't lose. What the heck is wrong? Show me the decision. And I start laughing, and I said, oh good, you're going to do a conditional acceptance. On what basis? See, remember, everything they do to screw you, how does your remedy go down? Your remedy goes down by confession and avoidance. The confession is all the facts you've said are true. Was there any fact that the magistrate had in there that was not true? Every fact was true. His conclusion of laws were bad because they were based on not all of the facts. He only included part of the facts he could see, not the facts he couldn't see. So you confess, oh, that decision was just perfect, i.e. Gordon. I want to send you a compliment, and who is your boss? You're doing such a fine job. You ought to be promoted for writing these decisions. We have just one little issue. We need to add some more information to it. But where is the information, and who does the additional information go to? Judge in chambers. But you got to explain to the judge what it is in an action statement, what you want him to do. So on a conditional acceptance comes now the undersigned authorized representative of the surety, and he's coming in, and the surety for the defendant, Joe Patriot, to tender this timely petition for judicial review on an administrative appeal from the magistrate's decision rendered on that date. The defendant accepts for value on all well-established facts and does not dispute any of the well-established facts contained in the magistrate's decision. Why would we want to argue with that guy? He did a perfect job. The defendant conditionally accepts for value the recommended conclusion of law and the proposed order for execution of the case contained in the magistrate's decision on proof of claim that the defendant has not timely submitted an evidence record of full consideration for set-off settlement and closure of the charges in plaintiff's complaint, and that this court should not adopt, public court, this court should not, I said recognize and adopt. Anybody looked up the legal definition of adopt? Can you look that up real quick online or something, or through Blacks? Look up adopt. Because in bringing our record to these people, that word is perfect. There's two definitions for adopt, one with family court and one with commercial contracts. Adoption. Turn your mic on.
Okay, so looks like family law is the definition number one. Definition number two.
Yep.
Okey-doke. Here we go. The legal process of creating a parent-child relationship. That's probably not what we're looking for. 3, contracts. There we go.
The process by which a person agrees to assume a contract previously made for that person's benefit, such as a newly formed corporation's acceptance of a pre-incorporation contract.
Okay, so you're assuming a pre-agreed contract. Okay, what was our certificate of protest evidence of? An agreement between the parties to use the commercial energy from your private set-off to set off, settle, and close the other contract, the mortgage contract. So we're asking the court to adopt the record of payment of consideration as a fact in this case and issue a new order judgment decree of discharge of the plaintiff's charges and a settlement, set off, and closure of the current case. So what we're asking them to do is basically confession, all the facts, add a new facts, and then by confession, we are asking the court to change its outcome based on the record of evidence of the new facts when we adopt the new contract for set-off. Then we want to settle and close this case. Make sense? Are we arguing? Have we brought anything that is not before the court in evidence? No. The petition of request is timely tendered. The magistrate's decision was rendered according to a notice sent to the clerk of court under rules. We get into all the rules and we substantiate why we're entitled to that. Let's not spend any more time there. Let's go to the next document quickly. Court's interim order. Oh, it gets better. This is shouting at us. Everything is in caps. As the defendant, Joe has filed objections to the magistrate's decision. Was it objections? No, it was a conditional acceptance. Oh, they're bad. They lied. Oh, but they're in public. Any brief in opposition shall be due on or before such and such. Any reply brief shall be due on or before then. So you can reply to this and then response to that. Counsel shall provide a courtesy copy where? Directly to judges' chambers by fax or by email of all notices of dismissal, motions, or any other pleadings that require the court's attention. Counsel shall not reply upon the filing with the clerk of court that the court has been noticed of such filing. Keep these documents in private? Wow. You don't believe anything we've been telling you this weekend? You need a second, third witness? I don't know. Who did say that? All parties shall serve upon counsel for the other party a copy of any brief filed with the court. Said notice shall be mailed to. Bring it up just slightly there, my friend. Opposing counsel by regular U.S. mail. Next document. The court judge just said, bring it to my private chambers. No signature. We don't care. Okay, here is the attorney now for the opponents. Okay, this is a cover letter. Enclosed, please find the original and 2 copies. This went into the court of plaintiff's brief in opposition in connection with the above referenced matter. So, okay, the party that put it in was the conditional acceptance of the magistrate's decision. Now, that conditional acceptance was filed in the public. Okay, then back comes the attorney for the plaintiff, and the plaintiff is filing a brief in opposition. What's that imply? Why did he file a brief? What could he have filed? A motion. Why did he file a brief and not a motion? Who would file a motion? A creditor. Who would file a brief to argue? A debtor. What did the attorney for the bank just do? Don't you people understand how you're playing this game? Because if you don't know how they're playing the game, how are you going to play the game right? A brief is an argument by a debtor. It's going to lose. If you don't like what's in their motion, put in a motion to strike or a motion in opposition. Don't you understand how to play this game, man? Yeah, but if it's procedural, it could go there. If it's substantive, it better not. Now, I'm wondering if the conditional acceptance should have probably more appropriately been private instead of public. We'll talk about that again in a minute. This is a cover letter. Let's go on to the brief. Plaintiff's brief. Now comes plaintiff by and through counsel and hereby respectfully submits this brief in opposition as a debtor to the objections of the magistrate's decision filed by the defendant. Defendant's objection is not an objection at all. I love it when attorneys can tell the truth. Sometimes it happens. In fact, he states in his opening paragraph of his pleading, quote, defendant accepts for value all well-established facts and does not dispute any well-established fact contained in the magistrate's decision, unquote. What is the attorney doing here for you? He's the second witness in your favor. Who says attorneys don't have a conscience? If you're doing it right, the attorneys are on your side. Yes, knowingly. Nothing happens by accident. He says further, the defendant conditionally accepts for value the recommended conclusions of law and the proposed order for execution of the case contained in the magistrate's, I don't know what went on there, magistrate's something or other. Is there a break between the top and the bottom? No, something's missing. The defendant does not assert that there was any error in the magistrate's decision. Defendant continues to assert the same unintelligible arguments. You can't see the truth. Concerning settlement, set-off, and closure, and refers to some sort of administrative appeal process. The defendant has continuously failed to set forth any defenses. Oh, thank God we didn't bring any public arguments. At no time did the plaintiff receive funds to pay off the amount outstanding on the note and mortgage. Well, naturally, you can't see those funds. There has been no settlement, set-off, or closure referenced by defendant. Consequently, since the defendant has not raised a sufficient defense, thank God we're not arguing a defense, to the allegations contained in the complaint, and since settlement and or payoff funds have not been received by plaintiff, the magistrate's decision should be adopted by this court and judgment awarded to the plaintiff's favor. Respectfully submitted, attorney. Let's go to next document. We have any problem with what this guy's saying? No, between the public and private, he's doing a perfect job. Now comes defendant's conditional acceptance of plaintiff's brief. Remember, the court said that the defendant could respond to the plaintiff's response. Comes now the undersigned authorized representative of the surety for the defendant, Joe Patriot, tender this timely conditional acceptance of plaintiff's brief in response to magistrate's objection, hereinafter brief. Okay, do we want to argue his brief? No. Do we want to agree with everything we can in the brief? Absolutely. What we are doing to his brief is the same thing we did to the magistrate's decision. Confession. Oh, he did such a beautiful job. He gave us credit where credit is due, and he missed some things, which when added to his brief, make his brief, the outcome of his brief, the opposite of what he said. Okay? The defendant conditionally accepts for value the contents of the brief on proof of claim that 1, the record, which is in private, the evidence submitted by the defendant to the court does not prove that the CFO of the plaintiff has not counterclaimed the defendant. In other words, on proof of claim that the CFO came back and put in a counterclaim. Nope, that didn't happen. And two, that the CFO has not counterclaimed the defendant to show, again, that this court's without jurisdiction or whatever. We can move on from there. See, we have sufficient consideration and that he's not placed an objection and that the court should not issue and enter an order, judgment, decree in favor of the defendant to discharge all public liability of the defendant in this case and to prepare an instrument to be filed in the county record showing discharge of the mortgage deed. That would be the second thing, which is title. And a closure of this case in favor of the defendant. The defendant further conditionally accepts for value the brief on proof of claim that to deny the record as a supplement to the magistrate's decision is not a tortious interference with contractual relations and not a tortious interference with prospective advantage. This is kind of like similar to what Brandon did when he said he put his explosive document in front of the judge. It was going to blow up. What is the definition of tortious interference with a contract or tortious interference with prospective advantage, young man? If you could look those up, Brandon, I would appreciate it. We'll share some information. Look up tortious. Tortious interference with, there's two. Tortious interference with contractual relations, tortious interference with prospective advantage.
Constituting
with contracts.
Constituting a tort, wrongful, in the nature of tort. And the definition of tort is a civil wrong other than breach of contract for which a remedy may be obtained, usually in the form of damages, a breach of a duty that the law imposes on persons who stand in a particular relation to one another.
Go down a little farther under tort, and you'll probably find tortious interference with contract and tortious interference with prospective advantage.
Tortious. What am I looking for?
Tortious, interference with contractual relations.
Tortious act, tortious conduct, tortious liability, tortious interference with contractual relations. A third party's intentional inducement of a contracting party to break a contract, causing damage to the relationship between the contracting parties.
Okay, in the record, who are the contracting parties?
Also termed unlawful interference with contractual relations,
right?
Interference with a contractual relationship, interference with contract, inducement of breach of contract, procurement of breach of contract.
See, doesn't the record substantiate that the defendant that came in through his record, private administrative record, had an agreement with the CFO of the bank to set off, settle, and close that, right? Okay, if this court denies that, aren't they involved in tortious interference in the contract between the parties? Would that cause a prejudice to the party that is in the defendant in this suit? You bet. But who else is in a contract here? Because is the defendant in the suit the party that's paying the mortgage debt? It's being paid for him by whom? By the authorized representative. Who's going to have the damage if this doesn't go through? The public trust, because...
Let's make a distinction real quick. The payment, we like to use the authorized representative because the authorized representative is the only one who appears in the public. But let's make a distinction. Who makes the payment? The private trust. The surety, the private trust. But the authorized representative is how the private trust appears into the public.
That's right. So actually the damage is by the surety. Now, the surety's already put the funds out there. And doesn't the surety have a security interest in the public trust? And if the public trust gets their assets seized in this foreclosure, is that going to have a direct effect on the security belonging to the surety? So is there not some kind of a background security agreement between the private trust and the public trust? There should be if you filed a UCC-1, right? Because that filing is a notice of a security agreement, which is held in private. And the security agreement held in private agrees what? That the surety, box 2, will pay the debts of the public trust, box 6B. In return, the assets of box 6B, including the land property, are then available to be liened by the surety for a secured interest. So this tortious interference with a contract could involve two sets of contracts. One between the private trust and the public trust, which can the judge interfere in a contract? Article 1, Section 10, public can't interfere in a private contract. And how about the contract between the surety, box 2, private trust, and the CFO, the private side of the plaintiff? Can the public interfere in that private contract? No. So is this a warning that this thing could blow up if they fail to protect some substantive rights herein? Okay, what's the definition?
Notice is hereby given that nothing is actually going to blow up.
Right. We're not talking terrorist explosives. We're just talking metaphorically that we've got a claim that could arise. Tortious interference with prospective advantage. What's that definition? Tortious interference with prospective advantage. It should be just right after what you read.
An intentional damaging intrusion on another's potential business relationship, such as the opportunity of obtaining customers or employment, also termed interference with a business relationship.
Oh, really? You think the court not protecting these rights might be interfering in a business relationship? Is the relationship between the straw man and the secured party creditor interference in a business relationship? The interference between the secured party and the CFO of the bank interference in a business relationship? Are these constitutionally prohibited torts? You bet. We having any fun yet? Okay, let's go on to the next document. Let's see what the court did. You just got to love it. It gets better. Yeah.
Just a real quickie. That sort of sounded like a terrific action that some of those folks who were representing 1099 OID interest and the IRS didn't like what they were doing, and they sought and obtained injunctions against them.
Okay, but before the IRS obtained injunctions against somebody doing 1099 OIDs,
They haven't obtained anything yet.
if they did, it's all illusion. If they did,
Okay.
the issue is there's got to be an administrative process first.
Okay.
You can't just go
yeah.
in and get a court order.
No, I agree with you on that. Those people.
And so
yeah.
in the private administrative process, if something came out, the only way they could go to court to get an injunction would be if there was a failure to respond, i.e. a dishonor, to the administrative procedure. I don't think parties involved, if they know what they're going to do, are going to fail to respond to administrative procedure. Because haven't we told you today that the administrative procedure is the trial? By the time they get an injunction, that's a judgment. We're way to hell down trial. We're in execution. So where the hell was the trial? They better have given them administrative. And if they give you a telephone call, if they give you a visit at the door, if they give you a letter in writing, if they send smoke signals through the Indian tribe, you had better respond.
I'm in perfect agreement that they could have handled things a lot better.
There you go.
Yeah.
Okay? Look what the court did. This is signed by the judge. Well, at least the electronic signature of the judge. All caps. This court has reviewed the objections to the magistrate's decision filed by defendant. This court hereby adopts the magistrate's decision entered, and the stay previously imposed is hereby lifted, and plaintiff shall proceed with its foreclosure. Oh, there you go. Everything we did was for naught. Damn. Not. What is this? A new public offer. Let's go to the next doc. No, not the last one. That's a non-doc. 17. Okay. 17 is victory. Okay, we put this on the public site. You know, we're all open to suggestions because, you know, we have really come a long way in doing this. Anybody see any interesting results from the public in what we were doing here? Doesn't it verify a lot of the stuff we're saying? Okay. Pardon? Now, we're trying to keep it colorable. Whether or not we succeeded filing privates where privates and publics, you know, that's what we're open to criticism. What did Brandon say yesterday on the process? Who was that process intended for? Not beginners. Why not beginners? Well, go ahead, beginners, give it a try. Okay, but the issue is, if you would have done some of these things at this level and got the responses from the judges, the magistrates, and the attorneys, would you have seen the tricks involved and been able to work a way around the trick and go on to the next stage? No. Does that mean that any of this process is not valid? No, they're not telling you anything about the process not being valid. They're attempting to go back with counter offers to get you to abandon the field. First person that leaves loses. Or they're going to try to get you to trip up, do something in public that should be private, private in public, or go into a dishonor. Okay, so we're doing our best staying power in here. The reason we're bringing this to you is it's not yet beyond this process. We're not sure where we're going to go next time, but what we're trying to show you is how to read these responses and the tricks these people are going to pull, plus to show you a lot of the cutting-edge stuff that we're doing. So now comes the undersigned authorized representative of the surety for the defendant, hereinafter defendant, to tender this timely conditional acceptance of the offer of the adoption of the magistrate's decision entered on that day. So we don't care if a judge put it in. Well, we'll see what we're going to respond to. The defendant conditionally accepts for value, returns for value, the offer on proof of claim that. Let's move it down, please. 1. This court has issued an ordered judgment decree that the defendant's record, which is defined as the private side there, of the case, the evidence submitted by the defendant of this court as to tender of full payment to the plaintiff of the sum of money due on the mortgage note and mortgage deed contract, and there is an agreement between the defendant and plaintiff by way of acts and actions of the CFO on proof of claim that that whole record submitted to this court for ratification, A, does not set forth a claim for discharge of the obligation to pay money under a simple contract, which comes straight out of your remedy in the UCC 3601. In the court's journal entry, that short one that says, we're adopting the magistrate's decision, did the court issue any findings of fact, conclusion of law? No. Did the court rule that this defendant did not tender adequate consideration? And so what the court doesn't say is more important than what they said. Having failed to say that it didn't meet its obligation, the court's silence has agreed that it did everything it did. What they don't say is more important than what they say. Okay? Did that journal entry say that this was a final judgment, order, and decree? How can anybody take an appeal? There's no final judgment, order, and decree. In fact, the court's journal entry wasn't a judgment, order, and decree at all, was it? It was an adoption. Are we going to hang our future based on an adoption? I wouldn't. I'm looking for a judgment, order, and decree. Or B, on proof of claim that it does not set forth a claim that the plaintiff's holding of mortgage note is not paid to the extent payment is made by or on behalf of a party obligated to pay the instrument, the defendant, or double I, to a person, the CFO, the plaintiff.
Jack, you're off. Batteries.
So under double I here on proof of claim that the plaintiff's holding of the mortgage note is not paid to the extent payment is made, double I, to a person, the CFO, entitled to enforce the instrument. In the bank, can't the CFO enforce the instrument? Yeah. To the extent that the payment greater than the amount due on the mortgage note. Mortgage note's $134 plus some interest, $160 was the payment. To the extent of the payment greater than the outstanding amount due on the note, the obligation of the party obliged to pay the instrument is discharged. Straight out of the UCC. We're quoting their own law right back to them. Are you telling us your statutes don't apply? 2, the contents of paragraph 1 is fully incorporated herein as if fully reproduced herein, and further that this court has issued an order, judgment, and decree that the plaintiff has an outstanding claim and public loss or prejudice on the mortgage deed and mortgage note that has not been discharged as set forth in defendant's records and the laws of the state of Ohio. And 3, that it is not the legal obligation of the plaintiff to adopt the record instead of us adopt the mortgage again. See, that was the words the judge used. He said that we're going to adopt the mortgage. Well, that was 2 contracts back. Let's proof of claim that we really don't want to adopt the mortgage, as that word applies to contracts as set forth in Black's 7th dictionary, a, quote, process by which a person agrees to assume a contract previously made for that person's benefit, unquote. Well, wasn't the record contract to the benefit of the bank? Did it not show that the bank has agreed that it had full consideration? Absolutely. And 4, that for the plaintiff to proceed or to be allowed to proceed with its foreclosure and to deny the undersigned's legal remedy for discharge does not prejudice the undersigned's lien hold interest and claim of subrogation against the mortgage debtor and create a substantive tortious interference with contractual relation and tortious interference with prospective advantage in violation of Article 1, Section 10, Clause 1 of the Constitution of the, to be continued, United States of America, which states in pertinent part that no state shall pass any law impairing the obligation of contract. Respectfully submitted. Enclosure conditionally accepted for value. We conditionally accepted the copy of the judge's journal entry and we returned it. There's a proof of service with delivery to all the parties. Now that's as far as this matter is gone. It's about maybe a week to 10 days old. And at this stage of the game, we're going to come back and see where this is going to go. Now, obviously, when teachers come to a conference, they're supposed to be taught by their students. And you guys have been teaching us all weekend as we have been teaching each other, Gordon and myself and Brandon, and we've got a lot of great new ideas for going back. Does this help you people understand how some of these court procedures come down, what some of the papers look like when you go public and when you go private, and how you can read some of these responses and pick out key words and also see that a brief in response is an argument as opposed to a conditional acceptance or motion. And you can see that the attorneys are dancing right in line. Has the judge, even in his journal entry, done anything negative or against the defendant creditor here, other than to imply we need to adopt? But doesn't the language of adopt say the parties are going to agree to a contract? Isn't that what adopt meant? Agree to a contract. How would you agree to his journal entry?
Non-response.
Non-response or argue.
Okay.
Did this party argue? Did this party fail to respond timely? So, when there is an offer in contract and when there is a counter offer, what is the current status of this case?
Counter offer.
The counter offer. The journal entry may be there, but under contract law, the journal entry has just been vacated. Are they going to respond to this? My assumption is they will not. They're going to go silent. Remember what Brandon said? Warning, warning, just because you do your process correctly doesn't guarantee you're going to get an automatic remedy out of the public. You may now have to do what? Go to step 2. What is step 2 after settling the account? Title. We got to get an agreement on title, because doesn't the bank still have a mortgage deed recorded? But has the bank got, under contract law, a valid judgment accepting that they have a right for foreclosure? No. But what would that allow the bank to do? Notwithstanding, could the bank sell its interest, whatever that is? You bet it could. It could sell its interest. To whom? Whoever's crazy enough after looking at this record to want to buy it.
Another bank. The creditor.
Well, I don't think another bank will, because it would put its stockholders at jeopardy. I think what in reality is going to happen is the following. I've seen it before. They're going to get one of their good business customers to be induced to purchase their interest at a so-called sheriff's sale, because based on the court record entry, they may go ahead with a sheriff's sale. If they go ahead with a sheriff's sale, are they prejudicing you? How are they prejudicing you? Huh? Violating what contract? Well, it depends really on, after the sheriff's sale, what kind of order would come out of the court that would be second witnessing the title of the party buying the property interest at a sale. Because let's say they just decide to go through a pure illusion, advertise in the paper and sell the property at a alleged sheriff's sale, which would go back to the court for an order from the judge on confirmation of sale. And the judge will say, yeah, the purchaser bought the interest. And for the protection of the interest, he is subrogated to the bank. What did the court just say? What title did they give the purchaser? Whatever title the bank's got, or whatever interest in the debt the bank's got, they've got, because they're selling the debt. But then after that, see, the sheriff's title is just going to be raw title with no guarantee. And based on that raw title, based on the confirmation order with no guarantee, then the buyer is going to come out and he's going to go to the court to get the possession rights. And when you go to the court for possession rights, what is that court interested in terms of subject matter? Right of possession has nothing to do with title. And they're going to assume that the guy coming in there because he got something at a sheriff's sale has a right of possession. In reality, the right of possession that he could legally have is common law lien. Because if he can't get possession, he has no common law lien. To go with the title, it means nothing. So again, it's just an illusion. So when you go into the writ of possession court, that has nothing to do with substance, it has to do with process. See, they go through what Brandon said yesterday, the threefold process. The first process is a notice on your door. Get the hell out. And what was the witness going to state in the hearing? Oh, yeah, I put it on the door. Okay, what do you need to do? Within 2 days, you need to what? Conditionally accept and return it on a claim. Now, do we care if they served it? No, we got a witness that said we reserved it on a counterclaim. Then the next thing is the summons from the court. What do you need to do? Conditional acceptance and return to the court based on the administrative process on the first. But now, whose process are we on? Our administrative process. And what is our claim? Who's coming in to make the claim of possession? Authorized representative for two. What's his authority? He's got the lien on the property because he put down the funds to pay off the CFO. And he better file a lien on the property based on that. Is the other party going to respond to his lien by which he has right of possession? If he's got all his records and his evidence correctly, his lien's as good as their approach for a lien. We're not talking titles. We're talking possession under the common law to protect my lien. I'm not talking my title by lien. I'm talking protecting my lien by the possession or something to that extent. So you just got to respond. If you respond and rebut it, they can't go on a default. They've been winning in court on default because nobody answers. That's an easy, cheap win. Okay, we're going to take a break.